Can anyone hear me?
Yes, we can hear you.
Okay, so I'll go straight to the point. The president had already given a background info of what we are here today to discuss. So, Dami had told me that I'll take the introductory part.
Yes, please.
Yes, if I'm going beyond that, you just give me a buzzer so that I don't delve into other people's part. So looking at the topic is the incessant contravention of the Compulsory Treatment and Care for Victims of Gunshot Act, remedies available to victims. We do know that an unenforced law is worse than having no law at all. And really, how laws are implemented and enforced and how compliance is ensured are critical determinants of whether regulatory system is working as intended. Sadly, 6 years after the enactment of the Compulsory Treatment and Care of Victims Act, Victims of Gunshot Act of 2007, which mandates doctors, hospitals to treat victims of injuries, gunshot injuries, without first demanding for a police report and initial deposits. Deaths arising from such refusal abound. The hospitals have disregarded this law, mostly because it's unenforced, to disregard this treatment, even when the law has mandated them. And it makes deaths arising from all those incidents very saddening. So we'll now look at our discussion will now focus on looking at the law to know if there are remedies these victims of gunshot injuries can have against the violators, if they can proceed in law to get remedies, whether in damages or even in mandamus against the violators of the law. So I'll now go back to the history of this ugly practice. In Nigeria, there has been a long history of denying gunshot victims treatment until they tender a police report. And this dates back to the period after the Nigerian Civil War. And this now necessitated the passage of the Robbery and Firearms Special Provision Act. That was the first law that was passed to mandate hospitals, doctors to treat gunshot victims. However, this Robbery and Firearms Act mandated them to report the treatment of gunshot victims. It did not state that hospitals and doctors should first demand a police report. It was the treatment that this act mandated them to report. However, where the report is not done, that is where an offense has been committed. Offense is not committed just by merely treating a person with a gunshot injury. Why this law was passed, the justification of this law was also to prevent where suspected kidnappers or armed robbers who had sustained gunshot injuries, it was to stop them from going scot-free without facing the law, maybe after they have gotten treatment and healed from the gunshot injury. Sadly, this Robbery and Firearms Act was misinterpreted. I would say gladly misinterpreted, because these victims, who are mainly even innocent victims, because you could be maybe in a crossfire and maybe a passerby, you get struck by a stray bullet, or even an armed robbery victim. Someone might come to your house, rob you, and maybe you get shot in the process. Then even the hospitals, even persons. Hello? Is someone saying something? So even victims who refuse to offer assistance to take you to the hospital. And I would just say they gladly misinterpreted this section of the firearms. It was section 2, subsection 2, that said the treatment should be reported while the treatment is ongoing. It did not make police report a precondition to treatment. So this now gave rise to so many preventable deaths. Even while several police commands, like IGP those days, following public outcry, gave series of directives to hospitals and even police officers who seized the opportunity of the Robbery and Firearms Act to harass victims, harass even hospitals and clinics who treated the gunshot victims. Police commands gave several directives to say that that is not the position of the law, but these continue to fall on deaf ears. They directed them to treat gunshot victims and only report the treatment to enable the police investigate circumstances leading to the gunshot. But however, it continued to fall on deaf ears, and the deaths emanating from those refusals continue to pile up. However, in 2014, following other cries from civil society groups, human rights, and even the NBA and then individuals, the National Health Act of 2004 came to somewhat ameliorate this deadly practice. The National Health Act made it mandatory for hospitals and clinics to treat emergency cases. Just said treat emergency cases. However, the National Health Act failed to explain what emergency cases were as. So hospitals now conveniently excluded gunshot injuries from emergency cases and also continued to refuse gunshot victims treatment until they tender police report or even tender initial monetary deposits. So this still boiled down to people who were still dying from gunshot injuries because of lack of refusal to even accept them for treatment. So to give legal backing to the Robbery and Firearms Act and even the National Health Act and also the directives of treating gunshot victims without first asking for police report and monetary deposit, the Compulsory Treatment and Care of Victims of Gunshot Act of 2017 was signed into law in December. The act has about, it's a small act with about 16 sections. It's about 16 sections. It came to mandate all medical practitioners to receive and accept victims of gunshots for immediate treatment without a police report or initial monetary deposit. So in its section, hold on please. In its section 2, it gave the right of victims, gunshot victims, it gave them right to receive assistance. Then it also gave the right of victims to receive immediate and adequate treatment. They said immediate and adequate treatment. It gave a lot of rights and duties because normally for every right, there's always a correlative duty. While it gives the victims rights of treatment, rights to be accepted for treatment, it also gave a correlative duty on healthcare personnel, even security agencies, and even individuals or good Samaritans. He gave them the duty to assist gunshot victims to get into the hospital for immediate treatment. There is no way, made it an offense. There is no way in the whole gamut of the law of that compulsory treatment and care of victims of gunshot. There's no way in it that it made initial deposit of money or even tendering of police reports a precondition to treatment. Sadly, even with all the rights and duties contained in this compulsory treatment of victims, the law still remains unenforced. It still remains breached. And I would think why it, like I said in my opening paragraph, I said, any law that remains unenforced is worse than having no law at all. And why is this keeps happening is because the police, who I think most times are also culpable in violation of this act, have also not been alive to their responsibilities of prosecuting offenders. They have not demanded compliance by prosecuting or enforcing the act. So this has given rise to so many that instances are abound. The one that just happened on 25th of December with the lawyer that was on Christmas Day, with the lawyer that was with her family in the vehicle. They were coming back from either a church program, Rahim, but it's even a local practitioner, Rahim. After they stopped them at a police checkpoint, it was actually even a police ASP that shot at her. She was in 2 different hospitals in Lagos. She was rejected under the pretext of demanding for police report before they could attend to her. It was at the 3rd hospital that she was declared dead on arrival. Instances are abound. Instances of all these are abound, and it's very, very worrisome. And it's very, very worrisome. Please hold on. So we'll now come and look at the remedies. Yes, we have noted that there's a law in place mandating hospitals or even security agents from giving treatment to gunshot victims, from or allowing them to get treatment without asking for police report or initial deposit. Then we also know that these laws or the compulsory treatment law has been arrogantly breached, arrogantly violated with impunity. So now we'll look at the remedies. Apart from the criminal offenses established by the Act, we'll look at and say, are there other remedies, even if civil remedies, where the victims can go and sue or ask for damages for breach, especially on the issue of the dignity of human person, the fundamental human rights of dignity of human person and the right to life. Because if you look at the Compulsory Treatment Act, it gave a right to victims. It recalled the fundamental human rights of right to dignity of human person. And the act of, because most times when these victims go to the hospital, they allow them, they give them the treatment that is contrary to that right of dignity of human person by refusing to or accepting to treat the victims. So we'll look at the remedies now. The remedies available to these victims will be to cause the enforcement of the act by filing a formal complaint to the police. Then I've also think that where the police, because most times they are culpable, refuse to act in that regard, there's need to escalate these complaints to different government agencies. You can escalate them, and the agencies that could be used to compel compliance are agencies like the Public Complaints Commission. The Public Complaints Commission, especially for victims that do not have the means to, the financial means to pursue their rights under the Act. They can go through the Public Complaints Commission. They can also go through the Legal Aid Council. The Legal Aid Council gladly has both civil and criminal powers to take up these cases. But however, also I think that why victims or even Nigeria at large, why they have not exploited or why they're not exploring all these could be because lack of ignorance, and also the lack of ignorance of their rights and lack of existence, even of the fact that Public Complaints Commission has such powers to help them to strongly ventilate their claims. Then with people that are buoyant enough to pursue these claims, they can go to court and ask for an order of mandamus to compel treatment. Then where treatment has been refused and there are consequential damages, victims can go to court and bring an action in medical negligence. Because the fact of refusal to accept victims for treatment, where the law has clearly stated, mandated you to treat them without any precondition to that effect, amounts to medical negligence. There are a lot of cases on that. And I have my paper, maybe I could send them across later. Then action for enforcement of fundamental human rights under the FREP rules. To fast track the claims, victims can go under the FREP rules, and also that in the FREP rules, the issue of local standby will not even affect even NGOs or other human rights agencies that might want to sue on behalf of victims. These are possible remedies. Then in recommendations, we had, I won't conclude, I'll just put my recommendations, then other speakers could go on. Then for recommendations, we suggest training and sensitization. I am not sure Nigerians, if we are going to go into the streets and ask questions and take interviews, I'm sure a lot of people are not aware of the existence of their rights under several laws, existence of their medical rights under several laws. So there is need to enlighten individuals of their rights. Also, inspection and monitoring, very important. This inspection and monitoring, there should be agencies, even the police, to monitor and inspect compliance. Let's say I also suggest that every hospital should have at least one police officer stationed in the hospital. This will help when gunshot victims are being brought in. The stress of trying to say, bring police report before you're treated, there's already the police officer stationed there could just take the inventory of what has happened. He will take the report there and do the needful without necessarily disturbing or having necessarily to put the burden on the hospital to do the needful. It will help also to fast track the treatment of victims. So I believe that police officers should be, at least one police officer should be stationed at every hospital. Then suing on behalf of gunshot victims. I've said it before, NGOs could take up the claims, especially for people that are not less fortunate in the society, to help them to get justice. Because once laws are enforced, once damages are awarded, punitive damages, it will serve as deterrence to other hospitals or other persons who may want to violate the compulsory treatment and care of gunshot victims. Then prosecuting erring police officers and hospitals. I don't know if any of you here has heard, I'm not aware, it's not a public knowledge that even one person has ever been prosecuted for erring or for violating the compulsory treatment and care of victims of gunshot. I am not aware. Then establishment of a compulsory treatment and care of victims of gunshot special fund. Most times I feel that hospitals, even when they are aware of the law, they use that law of initial police report as a marks to what really they want. Most of them are scared of who we pay. They're scared of the payment for the services, the payment of the treatment. So most of them just use the police report as a marks. And so if there's an establishment of a compulsory treatment and care of victims gunshot special fund, it will take care of so many things. It will also help reduce these deaths and also reduce the violation of this act. Thank you very much.
That presentation short and direct. Thank you so much, and thank you everyone that has joined. And somebody made a comment in the chat and stated that the enlightenment about this act should be extended to the Nigerian police particularly. And I think that's a very interesting recommendation. Thank you for everyone who has joined. I mean, I can see people in the chat who even joined from outside Abuja. Thank you so much for joining. Thank you, Barrister Grace. And I am hoping that you'll stick around towards the end, because we'll be having the question and answer section at the end of this presentation. Thank you so much. So thank you. So without taking much of our time, we'll go on to the next speaker. The next speaker is Barrister Oluwadamilare Adeoye. I'll be taking his bio. Damilare is a highly qualified legal practitioner with expertise in medical law and digital health law. He holds an impressive record of achievements, having served as an associate and a medical law consultant at First Counsel Solicitors, one of the leading law firms in Nigeria that specializes in medical law. During his tenure, he contributed immensely to the growth and success of the firm, earning recognition as one of the top performing professionals in his field. Damilare is the visionary founder and director of the Medical Law Hub, an innovative platform that focuses on addressing issues surrounding medical law and providing necessary medical legal views in practice. Through his leadership, the platform has become a hub for professionals seeking to deepen their knowledge and skills in medical law. Damilare is a research fellow of the Center for Medical Law Research, a prestigious organization dedicated to advancing the frontiers of medical law. He is the Southwest coordinator of the Human Rights Defenders Association of Nigeria, and also a member of several professionals associations, including the Medical Law Professionals Association of Nigeria, MELPAN, the Nigerian Training Institute of Medical Law and Health Law, and the World Association for Medical Law, WAML, among others. In addition to his outstanding professional achievements, Damilare is a prolific legal writer with numerous published work on medical legal issues in leading legal magazines, journals, and different national and continental outlets. His publications have earned him widespread recognition as an astute legal writer with a deep understanding of the intricacies of medical law. With his vast experience, expertise, and commitment to excellence, Damilare is a valuable asset to the legal profession and an inspiration to aspiring professionals in his field. Ladies and gentlemen, welcome Barrister Oluwadamilare Adeoye for his presentation.
Thank you very much. I hope I'm audible enough. Hello?
Yes, you're.
Okay. Good morning, everybody. It's good to be here. I'm delighted to be in your midst and to be speaking on a very important subject matter that affects all of us as lawyers, as Nigerians, as citizens. And it is something we have to really work on and not just talk on. I'm glad with the introduction and the aspects covered by the first presenter, and it kind of makes my work easier. Going for, can you make the presentation bigger, please? So I will be speaking more on the procedures, more specialized areas of this subject matter in a way that lawyers can really benefit from it. And thankfully, the first presenter has really done a good job on the history of the issue with gunshots in Nigeria, which is very vital to us understanding where all this came from. So please, the next slide. I hope I'm audible enough. Please, if I'm not audible, let me know so I can pitch up. Okay, so
you're audible, sir.
Okay, thank you. So we are all aware that it is a serious menace now, the issue of rejection by hospitals and healthcare providers when it comes to treating not just gunshot wounds, accident victims, knife victims. And I'm saying this because when this law came out, we felt, when I say we, I mean specialists in medical law, felt that it has already been covered by the National Health Act. However, we had to appreciate the content in this act because it further broadens those who are duty-bound to assist when issues like this come up. So we understand that this legislation is critical, but beyond the legislation, the implementation is even more critical. And that is where Nigerians are suffering. So today I'm going to be talking about not just the parts that have been already established, the fact that this is a problem, but how can we as lawyers help bring justice to victims, not to the victims, also to even assist, because the aim is not to crucify, the aim is to ensure that justice is done. And then we can help even the healthcare providers to do what they're expected to do under the law and under their profession. So please, the next slide. So this is a serious problem that we need to, first of all, we need to understand some basic terms that confuses not just the healthcare providers, but even Nigerians. Because we've seen cases whereby people assume that it is a right to be treated. it is your right to be treated, and that is not so. It is not your right to be treated, but it is your right as a Nigerian, as a citizen, as human, to get emergency treatment. And that is why we need to talk more on what a medical treatment is and differentiate it from what emergency treatment is. So when we are talking about medical treatment, it refers to a range of interventions and procedures provided by medical professionals to diagnose, prevent, manage, or cure illnesses, diseases, injuries, and all diseases. So these treatments may include medications, surgeries, can come in any form. So it encompasses the whole thing under treatment. However, when we are talking about emergency treatments, please let me have the next slide. It has to do with the prompt medical care given to a person who is in a critical or life-threatening situation and needs this immediately to stop further harm or injury. For instance, if someone is about to lose a limb or an arm, that is critical. So it's not just losing the life. So it's different from medical treatment. It is not our right to get treated in general, but it is our right to receive emergency treatment. So in summary, we need to be able to differentiate both as Nigerians, whether we are professionals or not. And this, of course, like the last presenter said, is a problem even within the medical profession, whereby they treat everything under the same umbrella. Medical treatment and emergency treatment. So the aim of emergency treatment is first to save life, which of course, it's one of the ethical duties of every medical provider. Save life before anything. And that is one of the battles we are fighting till date, whereby there's disregard for human lives, despite this act in place. So Section 1 of the act says every hospital in Nigeria, whether public or private, shall accept or receive for immediate and adequate treatment with or without police clearance any person with gunshot wound. So one of the things we say as medical law experts is it's not just even for gunshot wound, it's for every emergency treatment. As we see as I proceed in this presentation, that emergency treatment is a right, whether it's a gunshot or knife wound or even any injury or accident. It's a must, it's a right of every citizen, every human being, and so they should not be denied of it. And denying it is a serious crime against the hospital or the doctor or whoever is in charge. So the Section 1 covers this, since the act is mainly on gunshot victim, which is more rampant in our society. It specifically says without police clearance. Of course, in the act, it provides the process of getting police clearance after. However, it simply prioritizes life over anything else. Save life. That is the message. So if the patient is unable to consent, because there are always other issues like consent, right, it is always overridden by life-saving. Save the life, then every other thing can come after. So because implied consent is also another medical legal concept that is expected practitioner to know. So you should understand that it is implied that everyone wants to live. So save the life, and then we can talk about any ethical duty or other duties or responsibilities later. Can I have the next slide, please? So yes, so I'm going to be looking at the remedies from a different perspective. The last presenter has done a brilliant work. The first presenter rather has done a brilliant work in highlighting the remedies in general. But I'm going to be more specific now with the remedies, and I've divided them into three because this is serious, and we lawyers need to know how to go about it when they happen, or even before they happen. So I've separated them into three places. One is the criminal part of it, the civil, and the ethical issue involved in it. So now, what is the first thing we can do when this thing is going on or after? The first basic requirement, let's assume a life has been lost. That is a crime in itself. So it might be expected of us to advise our clients to report to the police station, because of course we cannot handle police cases, we cannot handle criminal cases. We can only ensure that justice is done in such instance. So the first thing is to report so that proper investigation can be done. We can identify the suspects and provide the necessary evidence when it goes to court, if it goes to court. Because one thing that is very critical, and which is why a lot of medical negligence cases fail in court, is that it's based on serious evidence. And like you always say, we say in medical law parlance, we say that if it is not written, it did not happen. So the issue with medical records, issue with case notes, issue with what had been done on the patient.
Hello, Barrister Damilare, are you there? Can anybody hear me?
I can hear you.
Yes.
Yes, I can hear you.
I can hear you too. Go ahead.
I can hear you too.
Yes, I can hear you.
I can hear you too. I think Barrister is having issues with his connection.
Yes, I can hear you.
Okay, looks like he's having issues with the network. So I was sorry about that.
I'm here with two people.
Good morning, sir. You're welcome, sir.
Good morning, Dami. My pleasure.
Apologies for this, for the interruption. He's working on restoring his connection. We're sorry about that.
So apologies, I hope I'm back.
Yes, you're back, sir. We can.
Apologies, I don't even know that anything went wrong. Okay, so it is important that we report first before any other thing. So, we can build on our case through that process. For us, the criminal lawyers we have here, I'm sure you can really, connect the dots in this instance, because you need to start piling your evidence. And of course, it is the right of every patient to have a case note, or case notes or medical records belong to the patient. So you can request for it on behalf of your patient, so you can use that to know what the next line of action. So please, the next slide. Okay, yes. So the second thing we can also do, like I mentioned earlier, is to make a complaint to the necessary health regulatory agency. So why I had to come up with that, or to use that heading, is, we are not only talking about doctors here, it could be the nurses, could be, because we understand that they are professionals in their own different field. And most of the time we make the mistake of assuming that it's usually or only the doctors or the nurses, whereas we have other professionals who, of course, owe us responsibility to be professional in delivering their duties in the hospital. So when we are able to pinpoint them, we can report them through formal paths to their associations or whatever disciplinary body is recognized under the law for them to be prosecuted accordingly. But we must note that if we go through this route, the best we can get is sanctioned for them, which means that they can't be fined. Like the Nigerian Broadcasting Corporation was ruled against recently, that they can't fine TV stations. Such applies in this instance as well, that the regulatory bodies, the disciplinary bodies can't fine, or they don't have punitive powers. The best they can do is sanction. So they can either expel or admonish the professional that has behaved unethically. So for instance, the Medical and Dental Council of Nigeria is responsible for that of doctors. So the way how you go about it is by writing to them in form of an affidavit, making your case, which if they find a reasonable case there, they can pick it up and take the case up from there, and of course follow it up from there. So it is another way, aside from following the criminal route, criminal case route. We can also go through this, and the good thing about this is they can run concurrently, can have a criminal case against them and at the same time file an affidavit against them at the Medical and Dental Council, or of course, depending on the professional we are talking about. If it's a nurse, of course, we have to file our case at the Nursing and Midwifery Council of Nigeria. And thankfully, since this is Abuja, they are all around your neighborhood, and so you can easily access them. The next slide, please. Okay, so the third one is, of course, the civil action. All this depend on the nature of the case and also what our clients want. So we all know that civil actions will bring monetary gains for our clients. So depending on the case, there are some cases that are good for civil actions as lawyers. So of course, the first thing is that has to be done by a lawyer. So the lawyer, of course, understands that you need to gather your evidence, which includes the medical records, witness statements, and any other relevant documents, like the case notes. We always advise that while lawyers file their cases in court, they try to get judgment or ruling from the Medical and Dental Council or whichever disciplinary body is on top of the case, because it helps solidify their case in court or the case in court. When the associations were, experts, disciplinary body of the profession has found a particular professional, medical professional guilty of an offense, it will be hard for a court not to find same, because that could even be tendered in court. So of course you file the lawsuit, court proceedings, and of course judgment, and then just the normal civil action way. And then you can make your claim at the end of it, if of course the judgment is in your favor or in your client's favor. So overall, the legal remedies available to victims who are not treated under this act, involves seeking legal action against the hospital or medical personnel, responsible for the failure. So the good thing about this law, or this act rather, is that it does not spare anybody. So it allows us to sue. Can I have the next slide, please? Oh, the previous, I think you've omitted that. Who can be sued? It should be in the previous slide. Okay. Okay. Anyway, let me go on. Let me go on so I don't waste our time. So this act has enabled us to sue anybody who has defaulted. For instance, the act has made it the section 14 of the act said that even a bystander, like the first presenter mentioned, who has failed to perform his duty in helping out, can be sued because he has failed in his legal responsibility in assisting a gunshot victim. So if such person can be caught, that means such person can be actually prosecuted for failing to perform his duty. Same applies to security agencies and hospitals and medical personnel. So it has expanded it. For instance, if you are to go through the second route, which is filing a case at their disciplinary tribunals, you cannot sue the hospital. Hospitals are not recognized as individuals. You can only sue individuals, professionals, and not the hospital. But if you are to take it to court, the hospital as a corporate person, corporate body can be sued in their own name, which is a good advancement in making a case or making them responsible. Someone is complaining about the audio. Am I audible enough, please?
Yes, I can hear you.
Okay, I have to, so I'm not speaking to myself. So having said that, we need to understand that beyond this, we need to work hand in hand so that we can even forestall such unfortunate situation. And the best way to do that is collaborating to assist in creating awareness, not just in to the Nigerian citizen, but even to these professionals, medical professionals. Because one thing I've realized, and we have realized in my hub, is that most of them don't know this thing. They really don't know. And when you tell them about this act, they'll be like, really? So we need to help them by educating them. Of course, ignorance of the law is not an excuse, but we cannot afford to fold our arms when they keep being ignorant. So we need to assist them by educating them through our platforms, personal engagement, professional engagement, on these issues so that they can rectify their defaults and the issues they might be, or the kind of mentality they have already. So the first thing is we need to create that public awareness. It's very key if we want to reduce this or to cut this off from our society. Like the first presenter said, we need to monitor as well. Because if there's no proper monitoring, it is unlikely that we'll get the best results. And I think the first presenter did justice on the monitoring aspect, which is, we can come up with a task force, special task force committee to investigate issues even before they happen. What is their state of mind in terms of seeing to emergency cases, even beyond gunshot victims cases? Emergency cases in general, accident victims, is it okay for them to reject any emergency case, not just gunshot victims? Is it okay for them to refuse, to treat in any instance when it is life-threatening? And of course, sanctioning. I think we need to find a way to make it easy. Because it's very hard. If there's anyone that's had opportunity to take up any medical negligence case, you agree with me that it is hard to get them as witness against themselves. That is, getting a doctor to testify against another doctor. It's always very challenging, and that shouldn't be. In fact, in most of these developed countries, there are professionals that act like expert witnesses and they are known for such. So you don't even need to stress. All you need to do is contact them and they will represent you. It is not like that. It is very hard in Nigeria to do that. So we need to find a way to ensure that they don't escape sanctioning when they should be sanctioned. That in itself will help. Also, there should be incentives. I'm still going to speak more on that because there are actually incentives that are not implemented for not just gunshot victims that have been treated, but emergency treatment administered by people are really complaining about the audio. Is this still okay?
I can hear you loud and clear.
It's okay.
I can
Very
hear you
much
loud
okay.
and clear. I can hear you.
Hear you loud and clear.
Hear you loud and clear.
Okay, then it's from their
I
end.
can hear you.
So I'm still going to speak more on the incentives because we do have some incentives that are not being implemented, in some other laws. And of course, we need constant review of the act. We need so that it can reflect, what is in our society. And we need to bring in, for instance, the police because they are part of the problem. The problem is always police reports. To what end? And despite them releasing different statements that it is not required, we still having it till date, to this present moment. Quite unfortunate, but that is why we need to bring them to the discussion. And why it is, this is very, very unique in itself. I mean, the act is because we are talking about emergency cases. We don't have the time to run up and down to either force them to treat. Before you force them to treat, you can't go to court this morning, for instance, to file a case and get, it doesn't work like that. So it's very, very unique in itself because you need urgency. It's critical. So before you go to court or before you even get to police station, life is going. Life is almost gone. So we need something that can always be there, that we can access and get, necessary treatment for not just gunshot victims, but even emergency cases. So in conclusion, processes and procedures such as compliance monitoring, sanctions for non-compliance, compliance incentives, and periodic law review can be implemented to ensure that the act is effective and relevant. Please to the next slide, please. So while I was making this presentation, I realized that it will be incomplete if we don't talk about the other essential laws that are relevant to this topic, to this subject matter, and that can even help us as lawyers to have a wider scope or understanding of emergency treatment and the legality around it, the laws around it. So I've highlighted some laws that you need to pay attention to. In fact, I was glad when the first speaker mentioned the National Health Act because it's more like the constitution in the medical law space. So the National Health Act is very encompassing, and I'm going to touch briefly on these laws for a wider view for lawyers when we encounter situations like this. So next slide, please. So we have the National Health Act. It is it's an act that was that came into being in 2014, provides a legal framework for emergency medical treatment in Nigeria. The act establishes the National Emergency Medical Treatment Committee, which is responsible for developing and implementing national emergency medical treatment policies and guidelines. So this act allows medical practitioners to provide necessary emergency treatment to patients. This itself encompasses what we now have in the Compulsory Treatment of Gunshot Victims Act, which is that you must treat before anything else. This act actually covered that a medical practitioner should provide emergency treatment in good faith and without the need for the patient's consent. Just treat first before any other thing. as long as the treatment is necessary to preserve the life or health of the patient. Specifically, the Act further provides for incentives that to date, we've not heard anything about it. It has not been implemented, unfortunately. Section 11, sub 3 of the Act provides that 5% of the basic healthcare provision fund that was established in the Act will be used for emergency treatment. So these are like the places where hospitals are supposed to get their returns on the emergency treatment they've administered. However, it has not seen the light of the day. Most hospitals will tell you, we are not running a charity center. Hospital is not a charity home. We need money to run it. And which is why we need to bring all stakeholders on board so that issues like this can be checked, looked into, and proper fundings can go around. Because eventually we are going to save more lives if funds like this go to where they are supposed to go to. The only time I heard about this fund was during the COVID-19 period, where it was diverted for COVID-19 purpose to get drugs and set up emergency stations for COVID-19 patients. So we need to channel this money to the right place if we want to see changes in the society in this regard. So Section 20 also provides that healthcare provider, health workers, health establishments shall not, emphasis on shall, not refuse a person emergency medical treatment for any reason whatsoever. So it was covered in the law that we had in 2014. So it was only because it kept happening that necessitated the Compulsory Treatment of Gunshot Victims Act of 2017. So we already had it, but of course, the clamor for such specific law led to, the one we now have in 2017. So it's a serious challenge because we keep having all these laws, piling them up, when in fact, all we need is implementation. Please, the next slide. So this is the Nigerian Medical Association Code of Medical Ethics. Like, it should be like a small Bible for all medical professionals in Nigeria, all doctors in Nigeria, because it states the ethical conduct, the unethical conduct, what is expected of them as a professional. And in fact, when they are being charged for any offense at the tribunal, this is what is used to measure their standard. So lawyers can look into this and see how we can help them and, of course, charge them to do what is expected of them. The next line, please. So we also have the Patient's Bill of Rights that was developed by the Federal Consumer Protection Commission, which outlines the right of patients in Nigeria. This also talks about right to emergency treatment. So we have all laws that, because of course, compulsory treatment of gunshot victims also fall under right to emergency treatment. So we have all these laws in place. All we need is seeing them happen in real life. All we need to see them being implemented. So the bill requires healthcare providers to provide prompt and appropriate emergency medical treatment to patients in critical or life-threatening situations. And the next one, please. And of course, it's if an healthcare provider is negligent, it can also come under the Criminal Code Act, and believe that we can prosecute them under this, where the administered care is reckless, or administered treatment is reckless in any way, or they did not even provide it. So we can come under the Criminal Code and say that this is a crime, and they can be prosecuted as such. The next slide, please. So thank you very much. I'm sorry for the disruption no thanks to network. And I hope I've been able to make my point. Thank you.
Thank you so much.
Thank you. Thank you so much, Barrister Damilare. Thank you so much. Thank you for coming. And thank you for the thoughts you have shared. We are so grateful. I mean, one thing I picked first of all from your presentation is the difference between right to treatment and the right to emergency treatment. Actually, this was my first time hearing it, that you don't have the right to treatment, but you have the right to emergency treatment. That was something I picked. And then I also picked up the fact that the saving life is the first move. That's the first thing every medical institution, every medical practitioner, regardless of their specialization, should care about. It's not getting police reports, it's not what is written and what is not. Let's preserve the life first. And also I picked up the fact that hospitals are concerned about their money. If we treat and they don't pay, who pays? So, and that goes back to the trust fund that Barrister Grace mentioned in her presentation. All of this is carried together when you said enforcement is what we need, because I'm seeing that the National Health Act actually has touched on the field of emergency treatment already. So implementation is what we need. Thank you so much. And we are glad. And thank you to everyone who has stayed this far. The conversation has been engaging in the chat. Thank you so much. So without taking much of our time, we'll be taking the last speaker. I have my questions already, so you can just keep notes of your questions, because after the presentation, we'll be having a question and answer session. So this is the last speaker, and I'm assuring you that you'll have a good time with him. The next speaker is Barrister Ebenezer C. Egwatu, and I will be taking I'll be reading his bio. Ebenezer C. Egwatu is a legal practitioner, medical law consultant, certified mediator, and a passionate patient right and safety advocate. He is the principal partner, Law Found Multidisciplinary Consults, a firm that provides innovative legal insight and cutting-edge solutions located in Abuja. He is also the founder and executive director of Lawyers Arise for the People Initiative, LAPI, a patient's right and safety advocacy NGO. He is a trained medical care assessor by International Medical Law Center, St. Kitts, North America. He is a member of Nigerian Bar Association, a member of the Medical Law Professionals Association, MELPAN, a member of the Institute of Medical and Health Law, an associate member, 3Cs, Met International Institute of Mediation, Negotiation, Counseling, and Conciliation, a member, World Association of Medical Law, WAML. He currently serves as the lead team for Make Our Hospital Work campaign, MOHW, a citizen-led community-based advocacy to improve the quality of healthcare services in hospitals and primary healthcare facilities across Nigeria. Ebenezer has over a decade on the field experience in HIV, AIDS, and patients' rights and safety advocacy. Driven by his passion for patients' rights and safety, Ebenezer, as an undergraduate law student, in over a decade ago, wrote his final year-long essay project on the rights of persons living with HIV/AIDS in Nigeria, a case study of the FCT, a critique. Ebenezer has also worked with Center for the Right of Health, CRH, a reputable NGO that is committed to health rights advocacy, where he volunteered as program officer and legal and human rights program for over a year. While at CRH, Ebenezer, among other things, worked as an associate editor and researcher of the book, The Right to Health and Violation of Patients' Rights in Nigeria, a desk review of health-related laws in Nigeria, published by the CRH in 2016. In the course of his patients' rights and safety advocacy, Ebenezer has featured as guest discussants on different radio and television stations, where he sensitizes Nigerians on their rights as patients and available remedies in the event of violation or abuse. In 2021, through his NGO, he trained 189 nursing and midwifery students of FCT School of Nursing and Midwifery, Gwagwalada, on promoting patients' rights and safety, the role of nurses and midwives, in commemoration of World Patient Safety Day 2021. Ebenezer has intervened in cases of health and patients' rights abuse, notable among which are securing the release of a newborn baby who has been detained along with his mother for 2 weeks by a medical doctor in please mute your mics as you're joining. By a medical doctor in Lagos State on account of the mother's inability to pay the sum of 70,000 naira only, being the outstanding balance of doctor for carrying out a cesarean section on the woman. Another intervention was mediating between an aggrieved patient's family and a government hospital in the FCT, leading to an apology to the family by the chief medical director of the hospital and taking responsibility for treating the patient at no cost to her family till she gets well. He's an avid reader, a researcher, and loves to serve humanity. Ladies and gentlemen, welcome Barrister Ebenezer Ekwati for his presentation. Thank you.
Good afternoon, ladies and gentlemen. Can you hear me, please? Hello?
Hello.
Can you hear me?
Yes, we can hear you, sir.
Awesome. Good afternoon, everybody. I am pleased to be here. I want to appreciate the chairman and leadership of the Garki branch of the Nigerian Bar Association, the Liberty Bar, for putting this webinar together. This webinar is long overdue, but it is always better to start than not starting at all. I want also to appreciate the two speakers that have spoken before me, Grace Okoro Esquire and my good brother Damilare. Awesome presentation there. Thank you. You guys have laid the foundation. I will just be building on what you have started. Okay, my slides, please. Let's roll. Slide two. I will be taking this topic from the perspective of compliance. The two speakers have spoken about the act. The first speaker, the second speaker talked about remedy for violation and procedure for getting that done. I will be focusing on compliance. What approaches do we adopt to ensure that this act is complied with? So, my introduction, can you broaden the slides for them to see? I am reading from my own system here. Okay. Introduction says the signing into law of the Compulsory Treatment and Care for Victims of Gunshots Act 2017 brought hope of living to victims of gunshots who, prior to the existence of the law, were subjected to obtaining police reports before they could be admitted for treatment in healthcare facility. Then, sorry, please. This practice of demanding for police reports before treatment led to avoidable deaths of many innocent gunshot victims. Then finally, this presentation illustrates the various approaches through which effective compliance with the Act could be achieved by healthcare providers, security agencies, and the general public to save the lives of victims of gunshots as intended by the Act. Next slide, please. Slide 3. Okay. To achieve the desired compliance with the provision of the Act, there is need to adopt the following approaches. So we have gotten to how we should secure or ensure that this Act is complied with. Number one for me is that the Act be reviewed or be amended. So we start by amending the Act. The Act, as it is presently, it has a lot of lacuna, which hampers effective compliance with the Act. For example, a lot of terms used in the Act were not defined under the interpretation section, thereby leaving each member of the public to his or her own interpretation. So anybody can give whatever interpretation he likes to particular terms used in the Act, because the Act did not define them and confine them to the context of gunwound victims' treatment. For example, the term immediate and adequate treatment, as used in section 1 of the Act, were not defined under the interpretation section. Hello?
I can hear you, sir.
Okay, so the question now, we're saying immediate and adequate treatment. It was not defined. For purpose of clarity, I will read section 1 of the Act so that we understand. It says, As from the commencement of this act, every hospital in Nigeria, whether public or private, shall accept or receive for immediate and adequate treatment with or without police clearance any person with a gunshot wound. Now, the act did not tell us what immediate and adequate treatment is. And we are posing these questions. Is arresting loss of blood by hospital adequate treatment? If someone, a victim, is rushed to hospital and all the hospital did was to arrest further loss of blood, has the hospital done adequate treatment on the patient? That's a question that needs to be answered. Is the hospital required to extract the pellets of the bullets from the victims or patients? So if must the hospital carry out a surgical operation to extract the bullet from the victim's body before we can say that adequate treatment has been rendered? Is pain reliever adequate treatment? If a patient is rushed because it's under intense pain and the hospital administers a pain reliever, could we say that the hospital has measured up by giving adequate treatment? So there is need to have a benchmark of treatment that should be considered adequate depending on the level of injury, the location of the bullet wound on the body, and the state of the victim/patient at the time of arriving the hospital. Let's go to the next slide. Okay, we also have, okay, I've already read section 1 here. So we have section 3.1, which also requires the hospital that receives treatment, that receives a gun wound victim to report to the nearest police station within 2 hours of receiving such victim. Is that practicable in Nigeria of today? The act did not specify the mode of reporting to the police. So if a doctor sends a text message to the police station, would we say that the doctor has complied? Can you hear me? Hello?
Yes, I can hear you. I can hear you, sir. We can hear you.
Okay, I just want to be sure that I'm not speaking to myself. If the doctor sends a text message to the police station, would we say that he has complied with this provision of section 3.1 of the act? Okay. If the doctor, is the doctor or nurse required to visit the police station in person and write a statement in that regard that they have received a gun wound victim and they are treating the that they have received the gun wound victim and they are treating the patient? Okay, do we even have directory of police stations or police outposts with designated functional phone numbers and an officer assigned to the desk for that purpose, such that if a doctor calls or there's a report, it can be assessed immediately and documented that we received a call from hospital XYZ that they are treating a patient? So we see that we have bad network, number 1. Sometimes we have fuel scarcity, number 2. So is it feasible and practicable that a doctor who is battling to save the life of a gun wound victim would at the same time be reporting to the police within 2 hours? So I think there is need to revisit this section of the act and incorporate the reporting mode, text message, WhatsApp message, email, phone call, all should be incorporated as means of reporting to the police, so that we don't have a situation where the police or the doctor who is supposed to be treating the patient now abandons the patient to go and report to police first before coming back. So we are also of the opinion that a hospital staff, not necessarily a doctor or a nurse, should be assigned to reporting to the police, so that where there's an emergency, okay, we know that our hospitals are grossly understaffed, though. So particularly some private hospitals. So if they have maybe 2 doctors on duty, then they brought in a patient, you now say one should go and report to the police. So the act should provide a particular officer, designate a particular officer whose duty it will be to make such reports, so that the doctors and nurses can concentrate on treatment. Then next slide, please. Slide 4. Slide 4. Is it 4 or 5? Okay, thank you. Thank you. Section 6 of the act should also be rephrased so as not to scare innocent volunteers and prevent them from helping victims. The section reads, a person who receives the report under section 3.2 of this act shall furnish the hospital on demand with the background information on the victim underlined, as he may be compelled to incriminate him. You help somebody, you are a stranger. The act says strangers should help. You help somebody that you don't know, then you are compelled to write a statement on his background, and that you may even be compelled to incriminate him. No. So this particular section of the act needs to be amended so that victims do not die because they don't get help from passers-by. So no person should be compelled to incriminate another person. So there is need to amend this section of the act for clarity. Section 9 also calls for amendment. The terms physical, emotional, and psychological damages should be defined in the interpretation section. The section should also stipulate what constitutes the said offenses. So once again, for clarity purposes, I'm going to read section 9. I didn't reproduce them here because so that I do not have too many slides. Section 9 reads, a person who commits an offense under this act which leads to or causes substantial physical, mental, emotional, and psychological damage to the victim commits an offense and is liable on conviction to imprisonment for a term of not more than 15 years and not less than 5 years without the option of fine. So what constitutes a mental, physical, or psychological damage? The act did not tell us. So there is need to get that done. Section 10 requires amendment because it reads, a hospital that receives any person with gunshot wounds shall notify the family members of relations of the victim as far as they may ascertain within 24 hours of becoming aware of the victim's identity. Question, who pays for the logistics to inform the patient's family if the patient has no phone number and doesn't have the phone number of any of his family members by heart? We have people who commute from one state to another and there is a mishap on the road. Okay, if they are attacked on the road and the Good Samaritan takes them to the hospital, you now say the hospital, upon identifying the patient, must inform his family within 24 hours. Who pays for the logistics? Where there is a language barrier and all the patient knows is his home state. Let's say the patient is from somewhere in Abuja and is hospitalized in Lagos. How do the hospital, is the hospital expected to fly from Lagos, transport from Lagos to come to Abuja to inform his family within 24 hours? So there is need to review this section of the act. Then section 13 requires amendments. It did not stipulate what constitutes offense by a corporate body. Section 13 reads, a corporate body that commits an offense under this act, the head of the corporate body shall be prosecuted in accordance with the provisions of section 11 and 14 of this act. Hello. Can you hear me?
Yes, I can hear you, sir.
Yes.
Okay, I got muted along the way. So I'm saying that section 13 requires to be amended. It says a corporate body that commits an offense under this act, the head of the corporate body shall be prosecuted in accordance with the provisions of section 11 and 14 of this act. So how will the corporate body know what constitutes an offense so that it doesn't commit the offense? So there is need to define what constitutes offense that a corporate body could likely commit as it relates to this act. So for me, that section is vague and it's hanging in the air. There is need for that section to be amended. We also have section 14 which requires expanded definition. For me, I'm saying that section 14 requires expanded definition of the word victim as used in that section to include the family members of patients or persons that sustained the gunshot in the unfortunate demise of the person that sustained the gunshots, so that his or her family would be entitled to compensation to be paid. Okay, let's look at what section 14 provides so that you understand. It says, in addition to any other penalty under this act, the High Court shall order a person or corporate body convicted of an offense to make restitution to the victim by directing that person or corporate body to pay the victim an amount equivalent to the loss sustained by the victim. Okay, let's assume, God forbid, the victim dies. How do you pay compensation to a dead body? So my suggestion here is that the family of the victim or the patient should also be incorporated as victim, strictly for the purpose of proper interpretation of section 14, and make it operational, such that in the undesirable event that the patient dies, his family could be compensated. Let's look at the next slide, please. Slide 7. Hello. Next slide. Next slide.
The slides have been moved. This is, or is it the next slide
Okay.
after?
That's slide 7. Yes, you're on point. Thank you. Okay, we have discussed implementation, amendment of the act as one of the ways to get it operational and secure effective compliance with the act. If all those lacunae are filled up and the act is proper, we can now talk about compliance. Even though as it is, we can be compliant, but I'm saying that for effective compliance with the act, there is need to fill in those gaps. Number 2 way to secure effective compliance is to implement provisions of Section 11 of the National Health Act. Once again, I want to thank my brother Damilare for discussing this earlier. So I will just elaborate a little more on it. It's the provision of the National Health Act. Section 11 provides for the establishment of basic healthcare provision funds. So there is need for government to implement these acts. Now the act reads, the section rather reads, there is established the basic healthcare provision funds in this act referred to as the fund. The basic healthcare provision fund shall be financed from federal government, grants from international donors, and funds from any other source. So let's look at the next slide 8. Money from the fund, next slide 8. Money from the fund shall be used to finance the following. It talks about what should be done, A, B, C, D. Our interest in the context of our discussion is 3E. 5% of the fund shall be used for emergency medical treatment to be administered by a committee appointed by the National Health Council. So slide 9, we are saying now that the implementation of the basic healthcare provision funds, slide 9, will provide the hospital with subventions to defray the cost of treating gun wound patients without initial monetary deposits. Section 2 says they should treat gun wound victims without initial monetary deposits. So my question now is, from which source? The hospital is also a business, so the owners should not be made to operate at a loss. Who will pay for the consumables, medication, surgery in some cases? So if the government implements Section 11, by providing subvention to hospitals, all they need to do is to build a database such that each hospital, as you treat, you impute the data. By database, I'm not just saying put things together. No, we are in digital age now. When a patient comes in, capture the patient's identity digitally, his name and everything with a photograph. looking at his state and the wound. So then, when you are done treating, you forward that picture and documentation to the government. You can even do a video recording. You forward it so that you will be entitled to get a reimbursement. But if you say, let them just treat, we will give you money, we'll have fraud coming in where hospitals might be coming up with fictitious claims for services not rendered. Government will also have a problem because they will not actually ascertain whether the treatments were rendered or not. So there is need for government to make Section 2 of the Act and Section 20 of the National Health Act achievable by implementing Section 11 of the National Health Act. So next slide, slide 10, trying to rush. So there is need. Section 20 of the National Health Act talks about, my brother Adam spoke to that section. It talks about hospitals not refusing treatment in emergency situation. Maybe I should just deliberate a little for clarity on that section. It reads, a hospital, a healthcare provider, health worker, or health establishment shall not refuse a person emergency medical treatment for any reason. I have had cause to deliberate or argue with some doctors on this session. When doctors are on strike, is it not a reason? When you bring a patient to a hospital and they say we don't have beds, is it not a reason for refusing treatment? We don't have bed. Doctor is not present. These are cogent, in quotes, cogent reasons. And what the hospitals do, most cases, is to dismiss the patients. I have always advocated that that is wrong because subsection 2 of that section says a person who contravenes this section commits an offense and is liable on conviction to a fine of 100,000 naira or to imprisonment for a period not exceeding 6 months or both. So you see that any hospital contravening the provisions, refusing treatment in emergency situation is liable to pay a fine of 100,000 if found liable, and the doctor could also go to prison for a term not exceeding 6 months. Now, what could constitute emergency? What the topic we are discussing today, gun wound victims protection and treatment, is an emergency situation. Pregnant women who are in labor is emergency situation. Snake bite is emergency situation. Scorpion sting, accident is emergency situation. There are a lot of cases that will come up as emergency. So I want to, if there are healthcare professionals here, I want to believe that there are
Hello, Barrister Ebenezer.
Suggestion to them has always been to do proper referral. Refer medical service. Okay, sorry, we're heading you to ABC hospital. You hand the what? Can you hear me?
Yes, yes, you froze for a bit, but we can hear you now. Hello, are you there?
Hello, can anyone hear me?
Yes, we can hear you now.
At what point did you lose me, please?
At the point of referral, where there's no bed, you were mentioning different types of emergency situations.
Hello? Okay, stuff that constitute emergency situation. I said pregnancy, accidents, gun wound victims, snake bite can constitute emergency situation, and a whole lot of them. So I am saying that what hospitals should do in that circumstance is to do proper referral by writing a referral note stating why they cannot take the patient. Maybe they don't have a qualified personnel to handle that case at the moment. 2, there might not be bed space. So let them make proper referral. But what we have here is dismissal. No, we can't attend to you. Okay, just go to the other hospital. It's dismissal. If you verbally say, go to hospital A, like my brother Damilare said, we always say, if it is not written, it didn't happen. So there is need to do proper referral. So back to our slide, slide 10. we are saying that the third way of ensuring compliance is sincerity of purpose by major stakeholders to ensure compliance with the Act. So there is need for sincerity of purpose by major stakeholders to ensure compliance with the provisions of this Act. It is not enough to promulgate laws. It is also important to take deliberate steps to ensure that the laws are complied with. The stakeholders here are the government, healthcare facility operators, that's hospital owners, proprietors, that's hospital owners, the police and other security agencies, healthcare professionals, doctors, nurses, lab scientists, sonographers, etc., and the general public. We are all stakeholders here. So there should be stakeholders meeting on compliance with the Act, after which each block passes the message down. So for example, if MPA at the national level sets up a committee, let me even say it here. The week MPA released its committees at the national level, I looked through the list, the committee set up. I didn't see any committee on medical law. So I called the one of the vice presidents, Mr. Democrats. I called him. I saw that I've seen what you people have done, but you people didn't put any medical law committee. So I'm using this platform, an opportunity to also appeal to our able president, national president, to look into that request. There is need for MB, it's part of my recommendations though, but let me speak to it now that it came up. There is need for us to have a standing committee, a medical law and patients' rights advocacy committee of the NBA. So if NBA takes up that responsibility, engages the police, engages healthcare professionals, and convenes a meeting. At that meeting, they will decide on how best to comply with this act and the urgency of the need of compliance. Then police people will go and do step-down training and pass the information down to their people. Hospital people will go and do same. Then the lawyers will come back home and do same. Then members of society, civil society groups who are participants representing the public will also trickle down that same information. Media practitioners will also be part of that. And so on. We now see health. The next slide, slide 11. Massive sensitization of the public on the provisions of the Act and the patient's rights generally. There is need to sensitize the public on the provisions of the Act and patients' rights generally. The government, through the National Orientation Agency, should sponsor radio and television jingles in different indigenous languages to sensitize and educate Nigerians on the provisions of this Act. I have also maintained that the way government campaigns against bush burning, okay, we just came out of a national election. We kept hearing different jingles against vote buying, against electoral violence, against all manner of things, so that we could have peaceful and credible election. In the same vein, the National Orientation Agency should take up the responsibility of sensitizing Nigerians on this Act, not only this Act, but every other relevant medical law Act that protects the rights of citizens, not only for health, any other law that is passed in Nigeria, they have that responsibility. NGOs, civil society organizations, religious institutions, community-based organizations will also take up the task of creating awareness creation and sensitizing their members on the provisions of the Act. Media houses, print, electronic, and online media should sensitize Nigerians on the provision of the Act as part of their corporate social responsibility. So when we have massive sensitization and awareness, people will know what the provisions are, then they will know what their responsibilities are and what the don'ts are. That way, we will begin to have a higher level of compliance. 12 here, we are saying build capacity building for healthcare professionals and security agencies, the police in particular, and on the provisions of the Act. I have had the privilege of speaking to doctors on this in 2021 or 2022 December. I was in Lagos to talk to the Loot chapter of the Association of Resident Doctors on medicine and the modern medicine and the law. And in the course of my interaction with them during the program, I discovered that they really know little or nothing as it relates to patients' rights. So there is need to build their capacity. When our organization did training for nurses in commemoration of the World Patient Safety Day, we also came back with the same observation that there is need to build their capacity in this area. So regular training and retraining on the provisions of the Act and patients' rights generally should be organized for healthcare providers till it becomes their normal mode of operation. So it is not having one seminar in 2023, we have another one in 2025. That's why we said regular training and retraining for them. So regular training and retraining should also be organized for personnel of different security agencies with particular focus on the police to ensure that their power to receive reports from hospital and investigate the report is not abused and turned to intimidation, harassment, and detention of healthcare professionals who are genuinely doing their job to save life. Hearing officers should also be disciplined to deter others from doing same. Slide 13. Slide 13, next slide. Hello. Awesome. Okay, there is also need to build capacity for lawyers on patients' rights violation, medical negligence litigation. Now, this is a technical area of practice. Your medical negligence litigation actually starts from the time your patient is in the hospital. Yes, your client as a lawyer, the litigation starts from, you're preparing for your case starts from the time the patient is hospitalized, because the patient has to do evidence gathering and evidence preservation. If it goes wrong there, you have nothing to present with the court. So there is need to train lawyers in this area of practice and build their capacity and in patients' rights enforcement / medical negligence litigation. Medical negligence is a technical area of practice. There is need to train lawyers in evidence gathering, preparing their processes, and getting right medical professional to testify as the claimant's witness. Now, for example, if your client in this case was attended to by a gynecologist, it will be wrong of you, a consultant gynecologist, it will be wrong of you to go and get an oncologist as your witness. You say there is doctor. No, you will lose the case. It's always best to get the witness that is of the same professional standing and capacity with the doctor you are prosecuting. So if you have a cardiologist, a consultant cardiologist who treated your client, and there was a medical negligence case. Now, your witness against that cardiologist should also be a consultant cardiologist. So there is need to train lawyers in this area to get them prepared for litigation in the event it comes up. This will no doubt increase medical negligence / patients' rights violation litigation, but also lead to more judicial pronouncements that will serve as both judicial precedents and case laws. With attendant damages awarded to deserving claimants, hospitals and relevant agencies would comply to avoid litigation and damages being awarded against them. Next slide. The seventh way of ensuring compliance is building capacity for judges, judicial activism, and enactment of patients' rights enforcement procedure rules. Yes, I said so. Our first speaker, thank you once again, Grace Ugomokoro Esquire, talked about enforcement, seeing patients' rights as a fundamental, bringing them under fundamental human rights enforcement procedure rules. Fine, it's a good suggestion. My advocacy here is that there is need to build the capacity of judges in this emerging area of law and also enact patients' rights enforcement procedure rules, the same way we have fundamental human rights enforcement procedure rules and Child Rights Act enforcement procedure rules. This will engender speedy determination of patients' rights violation cases, put the healthcare providers on their toes to comply with relevant laws, and respect the rights of patients generally. Furthermore, it will increase the faith of the common man that's victim of patients' rights abuse in the judiciary as his last hope of getting remedy or redress. Now, what we do now, most patients' rights most medical negligence cases have rights enforcement procedure. What it will do is, first of all, our patients' rights laws or the laws that guarantee patients' rights in Nigeria today are not codified in a single document. So you cannot say this is patients' rights law. What it's going to do for us is to now have a codification of patients' rights. The way we have fundamental rights under Chapter 4, we can subsume all these other rights into the National Health Act, which also requires amendments to make it more functional. So some of the rights we have under the Patient's Bill of Rights. The Patient's Bill of Rights is not an act of the National Assembly, is at best a regulation, legal framework for hospitals to work with. But we can pull some of those rights, those ones that are not contained in the patients in the National Health Act, we can put them into the National Health Act. So if we have a codification of all the patients' rights that are scattered here and there in different legislative in different pieces of legislation, we put them together, we'll now have a patient's rights document, one as a single document. We now have these patient's rights enforcement procedure rules. Now, our next slide explains this. Let's go to the next slide, please. 14. Slide 14. Okay. Here I define patients' rights as those rights that guarantee professional, quality, transparent, and safe healthcare delivery to patients, as well as respect for the dignity of the person of the patient by healthcare professionals while providing healthcare service to the patients. Now, this set of rights include but not limited to right to information, right to privacy, right to informed consent, right to refuse treatment, right to complain, right to treatment in emergency situation, that's one of which is what we are discussing, gunshots protection and treatment and care. Our judges should recognize these rights as what they are through judicial activism by awarding special damages to the deserving victims of abuse, and also award exemplary damages to forestall flagrant abuse of these rights by healthcare professionals. Next slide, please. So these are the rights, the ways we have discussed, the ways we feel, or I feel, that we can secure compliance. So below, the following are factors responsible for non-compliance. We have cases of non-compliance with the patient's rights, with the provisions of the act we are discussing. What factors could be responsible for such non-compliance? Number one, lack of awareness/ignorance of the existence of the act by healthcare professionals, police officers, lawyers, and the general public. So there is acute ignorance as it relates to existence of the act. A lot of people don't know. I made a post on Facebook some years ago, I think 2018 or 2019, and my close friend and classmate called me. He said, "Ebenezer, this thing you posted on Facebook, my husband, this is a lawyer, my classmate. She doesn't know, she called. She said, this thing you posted on Facebook, my husband has been suffering this type of maltreatment by his family doctor of over 20 years. So you mean we can do this?" I say, "Yes, madam, this is it." So lawyers do not know, doctors do not know, police officers do not know, the general public do not know. That is why there is a little or no compliance. 2, inadequate sensitization of the public on the existence and provision of the act by the government, NGOs, faith-based organizations, and community-based organizations. If at all there is information about this act, it is inadequate. Maybe when the act was passed, the media reports it, the government has signed into law, the president has assented to so and so act, Compulsory Treatment and Care for Gunshots Victims Act 2017, or for victims of gunshots 2017, and we clap, it ends there. That's not sensitization. Excuse me. So we also have absence of enforcement compliance drive by the government, the police, as well as relevant professional bodies and stakeholders like the NBA and the NMA, the Nigerian Medical Association, and the NBA should collaborate and champion compliance. So once again, I want to celebrate the Garki branch, the leadership of the branch, for putting this webinar up. This is one of the ways, as we sensitize our colleagues, the information dissemination starts. Every participant here now knows and should also sensitize his family member. So if I want to also throw a challenge to the chairman of the branch, my brother Obina, Obiomarada. So please, sir, after this, put up a proposal to the national body of the NBA on the need for us to collaborate with NMA and champion this compliance. If NBA and NMA come together, it will be easier to get the police to come on board, and we make progress from there. Then non-implementation of Section 11 of the National Health Act, which provides for subvention for hospitals to defray the cost of treatment of treating patients in emergency situation. Now, this is very key. If I am a hospital operator or hospital owner, to be sincere, I may not comply because you do not expect me to use my limited or scarce resources to treat a patient whom you say he shouldn't make deposits. Do you know that loss of blood, some of these stone wound victims in severe cases are transfused? You expect the hospital to go and get blood and transfuse the patients. Do everything and they won't get paid because you have said the patient should not deposit money first. Now, let me further emphasize on what my brother Damilara said. You have a right to treatment in emergency situation. Even that treatment in emergency situation does not culminate to right to free treatment. Even this one, the hospital, this act we are discussing, Section 2 says initial deposit of money should not be primary consideration. It did not say do not pay money after treatment. One of the feedbacks I also get from doctors when I engage them is that after treatment, patients refuse to pay them. They said, I have been treated. In fact, I'm in Nigeria. What has the government done for me? I'm not paying. You go to hospital, you see patients who are held back by doctors because they are unable to pay. In 2018, we had to undertake the rescue of a newborn baby who was detained in the hospital for 2 weeks because the mother could not pay 70,000 naira balance for the CS, the cesarean section the hospital performed on her. We had to intervene and got the hospital to release that baby. So a healthcare treatment is capital intensive. To run hospital is capital intensive. The hospital pays for the property, they pay their staff, they pay for the equipment. So government saying hospitals should treat patients without initial deposit of money, the government should make provision where the hospitals will have opportunity of getting their money back. Slide 17, please. We're almost done. I'll try to wrap this up in the next 5 minutes. Okay. Slide 17, recommendations here. I said for substantial compliance with the provisions of this act, the following recommendations are made. 1, amend the act by the National Assembly, amendment of the act by the National Assembly. 2, sensitization of the public on the provisions of the act by the government, NGOs, media houses, religious organizations, traditional rulers through advocacy, town hall meetings, etc. 3, set up compliance and enforcement committee comprising of the NBA, NMA, and the police. To add to this, we could have the media come in, we could have CSOs come in, we could have NGOs be part of this compliance and enforcement committee. We also recommend that we build the capacity of healthcare professionals, lawyers, the police, judges, and the general public on the implementation of the act from their respective perspective, professional perspective. Now, for the police, his duty is to receive reports. His duty is not to ask for police clearance before treatment commences. We train the policeman in that area. For the healthcare provider, his duty is to commence treatment. His duty is to report to the police that you have received a gun wound victim and you are already administering care on the patient. We train the person in that perspective. For the lawyer, we train him as it relates to litigation. We train him as it relates to evidence gathering and preservation. The same goes to the patient. We train the patient as to what his rights are, evidence gathering, and how to enforce these rights or seek redress in the event of abuse. So also train victims of patients on evidence gathering and preservation of evidence in the event of enforcing their rights through the courts. Then we also recommend that patients' rights should be recognized as a class of rights and the enactment of patients' rights enforcement procedure rules. 19, slide 18, please. Okay. The NBA should set up a medical law practice committee, which will, among other things, collaborate with relevant stakeholders to ensure the protection of patients' rights and compliance with laws that guarantee those rights. A conclusion. Victims of gunshots in Nigeria have for a long time been subjected to the harrowing and torturous condition of obtaining police reports before they could access medical treatment in hospitals across the nation. This practice, which stemmed from the misapplication of the provisions of the Robbery and Firearms Special Provision Act R11 LFN 2004, has led to avoidable deaths of many innocent Nigerians. To reverse this trend, the Compulsory Treatment and Care for Victims of Gunshots Act 2017 was signed into law. However, there appears to be a conspiracy of non-compliance with the provisions of the Act by healthcare providers, thereby defeating the objective of its enactment. There is therefore need for collaborative efforts by relevant stakeholders to ensure compliance with the provisions of this Act and save lives. Thank you very much. Thank you. We've come to the end of the presentation. If there are questions, I will be willing and available to take them. Thank you very much.
Thank you so much, Barrister Ebenezer. Thank you so much. Thank you for taking, that was an elaborate and very engaging presentation. Thank you so much. It's a privilege to have you here. So, ladies and gentlemen, senior colleagues, learned friends, thank you for staying with us thus far. I mean, the attendance has been consistent for the most part of this conversation, and that's very encouraging. Now, from Barrister Ebenezer's presentation, one thing that stood out for me was the issue of designating a personnel to report gunshot victims. I mean, it doesn't have to be a doctor, so that we can sort this issue of when to make the reports. So the person should be treating, should not be busy trying to report at the same time.
Contravention of the compulsory treatment.
Okay, sorry, I had to mute people whose mics were not muted. So thank you so much. And I also like you, Barrister Ebenezer, I'd like you to know that the MBA Gariki branch has a committee on medical law already. The branch has a committee on medical law. And thank you so much for that. And then I'm also aware that the MBA section on legal practice has a committee on medicine and law. That is a committee that we can walk through to getting the MBA at a national level, to get in touch with the NMA and the police to work on the enforcement of this act together. All we have to do is just pull synergy of effort, because from what I can deduce from your presentation, this addressing this issue is a multi-pronged approach. All hands have to be on deck. Because the interesting thing for me today is that anybody can be a potential victim. I mean, we don't pray, we don't hope it happens to any of us, but what if it happens? And the interesting thing about medical law practice is that everybody's a potential patient. So, I mean, even as far as the president. So, ensuring and safeguarding the rights of patients is something that should concern everybody. Thank you so much. Thank you so much. We are grateful for that. Now we have come to the question and answer sessions. So for persons who have questions, you can just put your question in the chat box, and we will be reading. We'll be reading. We'll just pick the questions. But I have a question. So my question is with the issue of covering up among medical practitioners, particularly. Now, Barrister Ebenezer, I know you mentioned that because that has been a concern. There's this almost like this, it's almost like a cult system. It is so difficult to get one medical practitioner to want to testify against the other. It's almost like, well, you don't do it. Like there's a sworn oath that you don't leave your brother to hang. So everybody just denies it. So, and that's a question. So when this happens, when the patient is having, or the victim is having challenge getting somebody to testify, what's the way out? What do we do? What's the patient supposed to do? And I'll be directing that to Barrister Ebenezer. Your mic is muted, sir. Can you unmute yourself?
Can you hear me now? Can you hear me?
Yes, I can hear you.
Great question there. Great question. Let me dispel that myth that medical professionals are usually not forthcoming. I agree to an extent there might be reluctance, but let me also give you good news that we have medical professionals who have come on board on these patients' rights and safety advocacy. So we have healthcare professionals, medical doctors who are part of members of our professional body of medical law, medical law professionals association of Nigeria. It's not only for lawyers. We have medical doctors who are members of the Institute for Health, for Medical and Health Law. It's not only for lawyers. So when our organization went for training of the nurses in 2021, we had a medical doctor who volunteered to be part of us as a resource person. And he went, and from the medical aspect, while I was talking the legal aspect, he was talking the medical aspect. So first and foremost, human life, let me also say that whenever a patient dies, I don't want to believe that there's a doctor who pops champagne and says, finally, we have done it. The patient has died, we have achieved our goal. No, they are not all happy about the decadence in the system. They are not happy about what is happening. So there are a few of them who are beginning to speak up, who will be willing to testify. So my advice is this: even from that hospital where the incident occurred, as a patient, if you don't know how to go about it, that is where wisdom demands that you engage a professional who will be able to assist, who has the training and the relative network to ask questions. Once he gets, okay, the person that treated me here is a consultant cardiologist. Within his circle of colleagues and friends, he should be able to also get, because sometimes we do consult. I am not a medical lawyer. I'm not a medical doctor, rather. I am a lawyer. And I have a retinue of doctor friends who I consult. When issues of medicine arise, I will call, sir, CC. What, okay, do this. This is what will happen. This is what should happen. This is what should happen. So the first thing to do where you have a case is to engage a professional. Engaging a professional, you have taken a bold step, not just a step, a bold and major step in the right direction. With good collaboration with the professional, that could be sorted out. But where there are the witnesses are reluctant to come. The court is there. We subpoena the witnesses to come and testify, even though they might come as hostile witnesses, but we will have a way of extracting the evidence we want from them. I hope that answers your question.
Yes, that was very helpful. Thank you very much, sir. I'd like to especially recognize Barrister Bulus Hassan, the former chairman of the branch, who is also attending, and also recognize Barrister Cyril Ojeonu, the head performance MET, National Agency for the Control of AIDS, NACA. Thank you for everyone who has joined. So I'm trying to read through, there have been commendations and praises for the presentation in the chat. I'm trying to see if there's any question from anybody. And so far, I don't know if anybody has any question and that they'd like to ask the presentation. Okay, so some people have requested that the slides be shared. I hope we have the permission of the presenters to share their slides.
Please, you do. You have my permission to share my slide. It's part of information dissemination.
Okay. Thank
yes,
you.
You have my permission to share my slide.
Thank you very much, sir. Okay, so so far, I mean, okay, send your messages. Yeah. Thank you so much for everyone that's attended, and thank you for the thoughts shared. We really appreciate our presenters who took the time to stay this far with us and who have really brought okay, someone's hand is up. Someone is raising his or her hand, so that means you want to speak. Okay, can you unmute yourself and speak? I mean, if you have a question.
Hello, Dami. It's me. It's Bulus. It's not a question.
Okay. Oh, good afternoon, sir.
Yeah, good afternoon. Well done. Well done to you. And I really wish to appreciate the speakers. I unfortunately couldn't attend from the beginning. I attended when Mr. Ebenezer started talking, and from his presentation, it seems like it's a summation of what the others have said. So I would take it that I didn't miss much. I wish to just make a small recommendation to the other recommendations, so add a small recommendation to the other recommendations that he has made. With regards to the cost of treatment of victims of gunshots, I will recommend that an arrangement be made for some kind of blind health insurance for such victims, since you can't tell who they are, but whenever they are treated in the hospital, such health insurance arrangement should be able to cater for their treatments, and the hospitals should be able to recoup the cost of such treatment afterwards. And then talking about the medical law committee also, I think it's a good thing that the branch has one already. The branch should be able to champion this cause with the national body, which has a number of committees that can liaise with the relevant stakeholders within this heading. We have the Human Rights Committee, we have the Security and Agency Relations Committee. So there's a wide range of communication channels that can be explored in giving effect to the wonderful and stellar recommendations that were made by the speakers. So once more, I want to congratulate the branch.
Thank you so much, sir. Thank you very much. Thank you so much. Okay, Mr. Roland Uwakwe, I can see your hand is.
Sorry, moderator. Please, before the next speaker comes up,
okay.
Let me just react to what Chairman Emeritus said. I salute you, sir. Good afternoon once again, Chairman. For the recommendation of insurance, the law has already made provision to cater for their needs, to cater for their payments. Section 11, subsection 3E has made that provision, that 5% of the basic health care provision can be channeled towards specifically treating emergency cases, payment for emergency treatment. The challenge we are having here is non-compliance. The law is there, the provision is there. So from 2018 to 2020, even 2021, monies are being drawn. But the challenge is that it is being channeled to a different purpose for which that fund was set up. So all the government needs to do is to ensure compliance. First of all, set up the committee that is supposed to man that fund, have a directory of hospitals who are taking care of gun wound victims. You can even designate in each state, you can designate, it mustn't be every hospital in Nigeria. You can designate, maybe in each state, you have 6 to 7 or 10 hospitals registered for this purpose. 1. 2, when victims go to hospitals that are not registered, they could receive first aid there and be referred to hospital that is under this program. Once treatment is done, you send your cost, your bill, the hospital, the government defrays you. So, but there is already in existence a means of defraying the cost of payment. The challenge we are having is non-implementation by the government. And once again, we are calling for government to implement Section 11 of the National Health Act. Thank you, sir.
Thank you so much, Barrister Ebenezer. Thank you for that clarification. Mr. Roland Wakwe, okay, you can unmute.
Okay, good afternoon, everyone.
Good afternoon, sir.
Let me start by appreciating all the speakers for wonderful presentation. I enjoyed all the lectures, and I plead that copies of the slides should be sent to our various emails. Perhaps we can include it in the comment section. Now, issues of perhaps negligence, and particularly this act relates more to issues of human rights, which the speakers have also pointed out. Now, my question really is, can you, instead of going through the whole hog of it, going through the civil matter, maybe bring it under the human right procedure?
Section 4.
I don't know. I don't know if that is possible.
Yes.
So you can fast track the process.
Let me explain. Patient rights, some of them are intertwined with human rights. For example, right to privacy is a patient right. It is also under Chapter 4 of the Fundamental Human Rights. Now, right to consent, right to informed consent is not captured under Section 4 of the 1999, under Chapter 4 of the 1999 Constitution. Right to refuse treatment is not captured under that section. Right to information as to the name of the doctor treating you, the name of the medication being administered to you, right to information as to the probable side effects of the treatment procedure that is being proposed to you. So these rights are not captured under Chapter 4 of the 1999 Constitution. And that is why I am advocating that patients' rights be recognized as a special class of rights, as a different class of rights. Now, if it is issue that borders on fundamental human rights, maybe a patient, even the right to privacy as it is captured, as is couched under Chapter 4 of the Constitution, is relatively different from right to privacy when we talk about patients' rights. So if a patient's privacy is abused in the hospital, he might not really get a claim, strictly speaking, under Chapter 4 of the Constitution. But if we have a codification of the patient's rights, and establishment of the patient's rights enforcement procedure rules, it will work faster. So that is a proposal I'm putting on board on the table, that patients' rights should be codified into one document. We already have the National Health Act, so we can subsume other rights that are not contained in that piece of legislation and had it as a codification of patients' rights. Then we now have patients' rights enforcement procedural rules, so that issues that arise from patients' rights violation can expeditiously be treated in our courts, and patients will be sure of getting redress. Now, if you bring patients' rights issues under Chapter 4, some may succeed. Yes, some may succeed, but a whole number of them will not succeed because Chapter 4 of the Constitution does not cover them. Thank you very much.
Thank you very much for that, sir. Barrister Damilare, I can see your hand is up. So, yep. Would you like to say something?
Okay, thank you very much. I just wanted to inform us. I don't know if there's anyone that attends the section legal practice conference here. We actually do have it under the branch. It's one of the branches there. I mean, the medical law committee is right there, and we always have a special session for medical law in the conference, during the conference. So it is something we can tap into and connect with at national level, so that we can have an elaborate implementation and discussion on this subject matter, because this is a national issue. So I think the conference is coming up this year in July. So I would encourage us to be part of it, so that we can contribute to this subject matter as well and be part of the committee. I'm not sure whether Mr. Laolo Sonyi is the president or, chairman or vice chairman, but I know he's fully part of it. One of the medical lawyers in Nigeria. I know they're well equipped for the task, and we can be part of them to put our support together and help with the implementation. And talking about these laws, now one thing I think we need to agree on is the fact that we have so many laws but less implementation. And I agree with my brother Ebenezer that we need to actually fuse these laws. We can't just have laws here and there. We need to fuse these laws. We already have the good of the Constitution that supports these laws, but when we have multiplicity of laws, eventually they will start to conflict. So we need to actually fuse these laws. For instance, as far as I'm concerned, the Compulsory Treatment of Gunshot Victims Act can be part of the National Health Act.
Section 20. Section 20. Yeah.
So we need to amend the major one, which is the National Health Act, and fuse all these lacunas, put them in there, and we have one solid law for issues of patients' rights and treatment, or medical law in general. So that's all I wanted to say. Thank you.
Thank you very much, sir. Barrister Cyril Ojeonu, your hand was up, Sir Homer. So, yeah.
Yeah, thank you very much. I want to congratulate the Gaki branch of the MBA for this very wonderful initiative. I have just about 3 to 4 things to bring out. First, I want to make a correction. The Basic Healthcare Provision Fund that provides for 5% is not for the victims. 2.5% goes specifically to address Department of Health Services, and 2.5 to National Center for Disease Control. This is according to the Basic Healthcare Provision Fund Operational Manual, approved manual that is in operation, developed in 2018. So it is that 2.5 that relates to the business of the issue of accidents or emergencies. So that's the clarification I want to make. 2, I think.
Sir, can you take that again?
I said the Basic Healthcare Provision Fund Operational Manual, approved operational manual. The 5% which is classified is on 1.1.6 emergency medical treatment gateway. It provides for emergency medical services shall be funded through the EMT gateway 5% of the Basic Healthcare Provision Fund. From this 5%, 2.5 will be given to the Department of Hospital Services and 2.5 to Nigerian Center for Disease Control. That is 5% is shared to address issues of medical emergencies. You can refer to the manual. That is the first. Then the second thing is that beyond this issue of what we have just said, the personal habits of people, most people don't carry their basic health data with them. Even the blood group, the genotype, and all those things, they don't carry it. So as part of the advocacy and sensitization, I think that should be included in whatever arrangement that is being made, so that on the first arrangement, the people will, the practitioners will have an idea about the basic information about the health data of the person. Then the third thing is this issue of scaling up the non-public sector health insurance. That is so that health insurance, our countries now, the third world, a very big and significant aspect of our health situation, our universal health coverage, is the fact that not up to 20% of health insurance coverage, compared to the civilized world where more than 98 or 95% is coverage. So if you don't have widespread health insurance coverage, you continue to experience this type of things. Because if there's health insurance coverage, all this issue of paying or not paying will not come in. And a lot of the people, non-workers, non-formal sector people are not covered under health insurance. That is a big problem. So I'm just picking up issues that needs to be taken up on board in addition to the legal dimensions. Whereas
Thank you very
we
much.
just in practice, we will not see any headway. Then finally, we have a lot of croppers who are medical doctors who have practiced medicine, and they are all over the country. We can reach out to them. I think in Benin, they have a small active group. I mentioned somebody in the post and others. You can put them there. Some of us are we have been in public health for at least the past 15 years, though not exactly medical doctors, and we're lawyers. So I think there's a rich arrangement of opportunities, but it depends on how we proceed. Thank you very much.
Thank you so much, sir. Thank you so much, sir. We're grateful for that. Thank you for the insights and the clarifications you provided.
Yes, further clarification on that.
Okay.
I think there is a review of the National Health Insurance Scheme. We now have a National Health Insurance Act, which I believe incorporated the informal sector. I have been going through the act bit by bit. I have not done exhaustive consumption of the provisions of the act. But with this that you have raised, I will go back and quickly complete that task so that I don't put out wrong information. But I know that there have been pushed before now for incorporation of the informal sector. Then on the issue of 2.5 that is given to the Nigeria's Department of Hospital Services, the express letters of the act, says that 5% funds shall be for emergency medical treatment to be administered by a committee appointed by the National Council on Health. I am aware that Center for Disease Control gets into health emergency. I don't have any query with it. They deserve, if not more than 2.5%. The COVID experience has shown us that. But the 2.5% that is given to the Department of Hospital Services, how is it utilized? Who is the endpoint beneficiary? My understanding of this, except that I have earlier called for a review of these laws and also appeal that to our lawmakers that when they are putting up any laws on any subject matter, they should endeavor not to hurriedly pass the laws, one, two, to engage professionals in those areas so that the bill should be properly scrutinized and every gap that could give ambiguity in interpretation be closed up. Because the letters of this act is saying for emergency medical treatment. Section 20 of the National Health Act says we shouldn't refuse emergency medical treatment. The common man's understanding. I agree with you, sir.
The Federal Ministry of Health.
I am not disputing with you. I am saying that operational guideline.
So please, I think you should read the manual first before all these things. I'm giving this confirmation as a professional in this area.
I work with
NACA, National Agency for the Control of AIDS, and we are day to day. We are in the middle of all this. So I'm giving you just the information. You can go and check it and all that. This is you can have a law, but putting the law in practice is what those manuals are talking about. This is the Federal Ministry of Health operationalization of the Act. So just go and check it. It's not a question of debate or not. Check it and find out.
I'm not debating. I am not debating.
Thank you very much, sir. And thank you, Mr. Ebenezer. Sorry, the branch chairman has his hand raised. So I'm sure he wants to make a comment.
Okay, thank you to our excellent moderator, Dami, for moderating well. And thank you to all the resource persons and participants who have contributed in one way or the other to make the webinar a success. The issue, like one of the contributors has said, this issue is a national issue. Issue of health is a national issue, and that led the branch to create a committee, medical law committee for the branch. And after this webinar, I think it will spur us to not just to continue working with the committee, but to make it to be more active so as to come up with more programs, not just for the branch, but for the general public, and especially for lawyers, because our main target is to a kind of spur lawyers to go into this area of law because it has a lot of opportunities yet untapped. Like one of the facilitators said, yes, most times the police come in to prosecute where needful, but most times the issue of civil litigation is neglected or underplayed. The other day we had the issue of Indomie, whether it is the ones coming into Nigeria, whether they are fit for human consumption and others. So it shows you that issue of health is an issue that touches every one of us. And this issue of Gunshot Act has also affected the bar personally, because some of our colleagues are late today because the medical personnel didn't adhere to the provisions of this act in offering the medical care. So I thank each and every one of us, especially the facilitators, for gracing this occasion. And we will continue doing our best to continue promoting this aspect of our practice. But what I want to ask, because I think maybe I didn't hear anybody say about it, this act, is it of general application? Do the state need to domesticate it for it to be applicable in their state?
Yes.
Or is it applicable to all the whole states? So that's the main question I want to ask. Thank you.
The states need to domesticate it, and Rivers State has already done that.
Okay, that's beautiful.
Yes, Rivers State has domesticated it.
Thank you very much, sir.
Thank you.
Thank you, Mr. Chairman. Barrister Grace, your hand is up. Would you like to say something?
Yes, please. I want to thank the MBA Garki branch for the opportunity. I also want to say that you have my permission to share my slides, and also to inform you that my paper on the topic is also available. Thank you very much.
Thank you. Thank you so much. Thank you very much, Ma. Thank you so much. Okay, and Barrister Damilare, your hand was up earlier, so I don't know if you still want to say something. We are rounding up or preparing to close this session. So I don't know if Barrister, yes.
Yes, can you hear me?
Loud and clear, sir.
All right. So I wanted to say something that is very critical, that beyond the letters of the law or beyond the process or procedures, we need to understand that we have a very bad system in Nigeria when it comes to emergency treatment. And we need to be holistic in our approach to it. Because the idea is not to prosecute medical professionals. The idea is to have a sane climb to handle emergency treatment. For example, we had the discussion on my hub a few weeks ago on when does it really matter when we are talking about emergency treatment? Is it when a person in need of emergency treatment gets to the hospital, or at the point where the person was shot or had the accident? And that's a critical question no one is even looking at. Meaning there's something we should look at called first responders. What is the protection? What is the process? Do you have a coverage for first responders? Because what we've realized is that nowadays, when someone is shot or there's someone in, a terrible situation in Nigeria, people look away. People just go their own way because they don't want to be implicated in courts in any way. So these are things we need to ponder on beyond the four walls of hospitals before we even talk about professionals handling the situation. The ordinary citizen, first responders that are on the scene, is there a coverage for them? So as we go on in talking about these issues, we need to expand our scope and reason in terms of when this thing happen, the first person that goes there that is probably not even knows nothing about treatment, does the law envisage such person? And is there a cover for such person? For instance, in some states in the United States of America, there's something called Good Samaritan law, which means that at that point, if you go on and try to save life as an ordinary citizen, you won't be held responsible like a professional, or you are protected. And we don't have such in Nigeria. So as we continue to engage in this discussion, we need to expand it to that point where, the idea is not to actually focus only on the professionals. Citizens do have duties and responsibilities to protect life, and we must expand our laws to cover the whole scope. That is all. Thank you.
Thank you. Thank you very much. Thank you so much, sir. Thank you for bringing that perspective of the Good Samaritan. It was actually one of the things I noted, but Barrister Ebenezer had sort of addressed it because I was concerned that, okay, what if a Good Samaritan in the bid to try to do good does more harm than good? And then something happens. So will the Good Samaritan be held culpable for being negligent? I mean, what if I don't know how to perform first aid, but somebody was shot beside me? And out of sense of humanity, I'm just trying to be nice and kind and help the person. So that means we have to look into protection for Good Samaritans too, if we want to encourage compliance. And thank you so much. This is 1:30. We have been here for about 2 hours, 30 minutes. And it's been a very engaging, interesting conversation. I see people who have been here from the beginning. Some people were even here before the webinar started. Thank you so much for joining. And thank you to our speakers, Barrister Grace, Barrister Damilare, Barrister Ebenezer. Thank you so much. And thank you to the branch chairman for this opportunity. So on behalf
of...
Can you hear me? Yes, I can hear you,
sir.
Shutting
down? Okay. I just wanted to say that Section 8 of the Act protects volunteers who we call Good Samaritan in this instance. But by way of education, when we begin to do massive sensitization, there is also need to have people trained on first aid. It's not just because you are zealous to help. There is even ways to carry patients. You might, in the zeal to assist, cause further damage. So the persons you refer to, we've got Good Samaritans here we will just do our crude things. Okay, carry him. If there is a spinal cord fracture now, there's a way you carry such patients. the patient might not, his case might not be worse or could be worsened now by those who came to assist. So these personnel, these good Samaritans, they have to have basic knowledge of first aid and carrying patients. So what it means is that there could be need to begin to champion another advocacy totally for people to volunteer and be trained in this area, so that if they just run into accidents or this, they can know how to carry and respond appropriately. Thank you. But as for protection, the Act, Section 8 of the Act, protects persons who volunteer. In fact, it says every volunteer or helper of a victim of gunshot shall be treated with respect and shall not be subjected to unnecessary and embarrassing interrogation in their genuine attempt to save life. So they are protected under the Act, but there is need to train them, for them to have basic knowledge of helping out in that direction. Thank you.
Wow, thank you so much for that, Barrister Ebenezer. Thank you for shedding light on that. Thank you so much. We are wrapping up and we are at the close. Thank you so much, everyone, for being with us so far. We appreciate you for your time. And on this note, on behalf of the Nigerian Bar Association Garki branch, on behalf of the speakers, on behalf of everyone present, I want to say thank you. Have a wonderful afternoon and enjoy the rest of your day. We look forward to seeing you in our next sessions. Thank you so much. Have a good day, everyone.
Thank you.
Thank you.
Thank you. Yeah, this was lovely. We enjoyed it. Thank you so much. And it's for free. Thank you.